calling for the mother, and I believe I see the mother, Madison Oller.
Yes, sir, I'm here.
Thank you very much. And Justin Trosclair, Juan Carlos Salazar. All right, no answer, nor is anyone presently in the waiting room. So I believe earlier when I made the inquiry, the motion was not agreed to other than the agreement to proffer. So if that's not still the case, somebody let me know. Otherwise, let me get everyone sworn in who may testify. And well, actually, I don't need that so long as you all agree to proffer. So Mr. McCatherine, you may proceed whenever you're ready.
Thank you, Your Honor. Your Honor, if we were to offer testimony in this case, I believe that this is what would be shown. October 18th, the children were placed with a maternal grandparent since the beginning of the case. That is my client, the mother's, that's her parents, and her visitation has been at the discretion of her parents, supervised at all times, but she's able to go by there, spend significant amount of time, and she takes care of the children when she can, even though she does work during the day and is able to work from home. She does spend very much a lot of time with them, but under constant supervision of at least one of her parents. Back in November, it was November 15th at our status hearing, Ms. Oler requested the requirement of supervision to be lifted at that time. And Your Honor took that under advisement. We proceeded on through the holidays, and I was contacted by Ms. Oler in January. She informed me that the caseworker, Stacy Pittman, worked with her to create an 8-week unsupervised phased-in visitation schedule leading up to the initial permanency hearing. I contacted all the parties, all the participants, I'll say, inquiring about this plan and if we could implement that plan. I was advised that the department did not agree to the unsupervised visits at this time. I was also advised that they proactively created this plan in the event the court would order unsupervised visits in the future or monitor return, but not for the present time. So we are requesting at least some unsupervised visits, Your Honor, and at a minimum, implementing this 8-week phased-in plan that I believe was crafted by Ms. Pittman and my client. And so it goes through 8 weeks, and it was my understanding, and I could be wrong, but it was my understanding that this was to play out 8 weeks prior to the initial permanency hearing that is in end of March. So that's my understanding, Your Honor, just in a nutshell. And in regards to compliance, my understanding is that she's tested clean, done everything that's been asked of her. And I believe she has some ongoing counseling and some other things. But other than that, I believe that she's fully or adequately in compliance with her service plan.
All right. Thank you, Mr. McCatherine. What would the evidence show in relation to the whereabouts and or any contact the mother may have with Juan Carlos Salazar and or his mother?
I don't believe that my client has any contact with either of these gentlemen, either of these fathers. I do know that one of the grandmothers was given visitation, scheduled visitation. I can't recall which one it was. But I'm not sure what her relationship is like with Ms. Salazar or Mr. Salazar's mother.
Any other proffer of any other witnesses, Mr. McCatherine?
I'm looking to see if the placement is here, and it doesn't look like they're able to make it. So I don't think so, Your Honor. I believe that would be it.
Are you asking about the placement of the kids? My mom's next to me. She has the kids.
Oh. Well, we're not calling witnesses, so I think we're okay for now, Judge.
Okay. Who's going to proffer Ms. Stanley's testimony?
I will, Judge. So, Judge, I believe that the testimony would show that currently the mother in this case, as Mr. McCatherine said, is having visits with the children at the discretion of the parents, supervised by her parents, who are the placement. She currently is at the home Monday through Friday at 6:30 a.m. She gets the children up, feeds them, gets them ready for school, and then she goes to work. She comes back to the home around 5:15 and she's there until they go to bed. She feeds them, gets them ready for bed, does that. On Saturdays and Sundays, she gets there around 7 a.m. and she's there until they go to bed. I have not seen this 8-week plan that has been created, so I cannot speak to that specifically. I can tell you that she has completed only 2 counseling sessions. She has not completed domestic violence sessions. It is my belief and the guardian ad litem's belief that she hasn't fully addressed the issues relating to the removal. The infant in this case cannot speak and cannot self-protect. Both my recommendation and Ms. Stanley's recommendation is that she be allowed to have unsupervised visits on Saturdays and Sundays with the oldest child in this case for up to 8 hours, maybe from like 9 to 6. That she be allowed to take the oldest child to her residence as well, with the caveat of this. We don't know how he's going to respond. We don't know if it's going to cause him more confusion going to his home and then having to go back to his placement, or if going to his home will be something that's good for him to see his home and play with his toys. So we would like it to be up to the placement, the maternal grandparents' decision based on how he responds and how going to his home affects him, if she's able to continue to take him to his home. We are requesting that no adults be around the child during that unsupervised visit with the oldest, unless they're related by blood or marriage. Obviously, that he not be left alone with anyone during that unsupervised time. We believe that that is in his best interest, the oldest child, and that he really needs that time alone with his mother. We think that that's a good step in giving her some responsibility and seeing how that goes. Our concerns with the youngest, again, is that he can't speak, he can't self-protect. He is the one who was injured in this case. There is a concern because even in the psychosocial, it's stated that there were limits on testing, was that her inability to be accurate and honest about the reasons for the removal. And of course, with her lack of completing services, only 2 counseling sessions doesn't address the issues. So we're concerned about that for him, and we are not recommending unsupervised with the infant. I will tell you that I do believe that Miss Susan Oler, the placement, would testify that she also is in agreement that the oldest child have unsupervised visits, and she believes that those visits are in his best interest and he needs that time with his mother.
May I just say I've done 6 counseling visits, not 2.
Okay, Ms. Moore, did I hear you say Saturday and Sunday?
Yes.
Okay, and I think I heard, or at least I wrote down, 8 to 6.
Oh, 9 to 6, 8 to 6. I'm not really concerned about the times. I mean, just whatever the court thinks is important. We just think a full day would be appropriate.
So right now, Mom is getting there about 7 a.m. on Saturdays and Sundays. What time is BO's bedtime?
So I am happy to report that he is on a very good schedule now, and that his bedtime is 8:30.
Okay,
And that he has been, since being on that schedule, he's actually improved in school, his behavior, everything. So that's worked out well for him.
right. Okay, excellent. And Ms. Moore, if you know, how far are the residencies apart?
I
Mother-
do not know that, Judge. I'm sorry. I think Mr. McCatherine may be able to tell you.
Minutes.
Minutes, okay. That answers it. Okay, all right, thank you. Okay, Ms. Davis, to you.
Thank you, Your Honor. The department would agree with the proffer of that Mr. McCatherine provided regarding mom, that she is in compliance at this time, but has not yet successfully completed all of her services. There was a reason to believe found as the disposition for neglectful supervision in this case. And ultimately, we have an infant who was injured, and that is why this case came about. Because mom has not successfully completed her services, the department cannot be in agreement for unsupervised visitation. There was concern that mom had lied significantly to the caseworker, Ms. Pittman, about the child being alone with the father because she was trying to protect him because he had a warrant out for his arrest. Ms. Pittman believes that mom acknowledges that she did lie at that time, and that it's opened her eyes to her relationships and that she needs to put her children first. But mom has not fully demonstrated at this time, based on not completing those services such as counseling and the domestic violence assessment and recommendations that are the true root of the issues that brought the child into care. And so based on that information, the department would not be in agreement to unsupervised visits at this time.
All right, thank you. And when you were referring to the child and the father, were you talking about JS and his father?
Correct, Your Honor.
Okay. Do you know what the evidence would show in regards to how many of the 18 BIP classes the mother has gone to?
I do not have the exact number, Your Honor. I can try to get that real quick.
Didn't I hear that she's in BIP, I assume, as a victim?
I can tell you, Judge, that when I spoke to Ms. Pittman yesterday, I was told that she is not able to do the domestic violence at the same time as her individual therapy. So the domestic violence therapy she hasn't been able to start that yet.
Okay. So is this domestic violence therapy in this situation, is that synonymous with BIP?
That I can't answer.
Okay. So can somebody tell me, I believe mom interjected that she's attended 6 and not 4 therapy sessions. Does anyone know what the evidence would show relative to whether within those sessions DV is being addressed?
I don't know whether it's being addressed, but I will say that I believe that Ms. Pittman would testify that there have been, at least from my conversation with her yesterday, that there have been 2 counseling sessions.
So is it fair to say that your and I guess Ms. Stanley's recommendation were based on mom having 2 sessions?
Well, it wasn't completely based on that, but that is one of the factors.
Well, of course not, but it was one of the factors that she had 2 and no more in your view at that time.
Yes, Judge, and I can tell you that even if we are mistaken and if there's been 6, we still don't believe that unsupervised visits with the infant is appropriate at this time because of the other concerns. And also because we do believe that the oldest child needs some time alone with his mother.
Sure. Okay. All right. Thank you. And Ms. Davis, I'm not completely sure that you were finished. So let me let you finish if you haven't.
I didn't know, Your Honor, if you were interested in seeing the plan that was drafted by Ms. Pittman with Ms. Oler. I've circulated that earlier in the month, and I just provided a copy to Ms. Moore, and she had not had a chance to look at it.
Okay, I have enabled the screen share. If you want to publish that, you may.
2 with family services with Faith, and 4, I guess it's individual with Sherry Wood, I believe. So that's 6 with 2 different therapists.
Okay, so 2 family, 4 individual.
Maybe that'll help clear it up a little bit.
And Your Honor, I'm ready whenever the court is ready.
Okay, go ahead, Ms. Davis. And then after Ms. Davis, any objections to the visitation schedule?
No objection.
No, Your Honor.
Okay, and I understand this was not something the department was pushing or recommending or asking for, but rather should I order it? This is just a possible schedule that
Correct.
we'll work with and live with. Okay, all right. So, okay, go ahead, Ms. Davis.
Regarding the BIP classes and counseling, the department has been having trouble finding someone to facilitate BIP, and so that is not what she's working on. Currently, Ms. Oler has 2 separate counselors, one that's therapeutic and one just a regular counselor, and she had 2 of the 13 sessions regarding the domestic violence with the therapeutic counselor, if I have that understanding correctly. Unfortunately, it's a conflict of interest for her to have 2 separate counselors. And so therefore, recently a conversation had been had with Ms. Oler, and she has chosen to stay with the original counselor and not continue with the therapeutic counselor. And so therefore, at this time, the department is just recommending she continue as long as that includes domestic violence, and they're able to address those issues in those counseling sessions. The department's going to work on trying to find something else, either online or another facility, to help actually address the issue of either like a BIP program or one that's more narrowly tailored to domestic violence victims.
Okay, all right. So this is being done in light of the unavailability of BIP, and in essence in lieu of BIP, because we'd be running out of time since BIP is generally 18 weeks.
Yes, Your Honor.
Okay. Okay. All right. Then any objections to Mr. McCatherine showing us the visitation schedule?
No, Your Honor.
Yeah. All right. You may, Mr. McCatherine.
I don't know if it's appropriate, since we're proffering, if Ms. Pittman wanted to maybe describe what that was, or what the intention was, if that would help.
I'm sorry, Mr. McCatherine, what did you ask me?
Oh, no, don't talk just yet.
Ms. Davis, do you want to proffer anything relative to the department and its preparation of this?
Your Honor, I know that Miss Pittman and Miss Oler worked together to develop this plan. Honestly, this is my first time seeing it, so I don't know any further information than that, other than it was prepared with the anticipation that mom was in compliance and doing well. Not in agreement yet to move forward with that or recommend unsupervised visits, but that if the court were to order it, then we would have this plan in place or available to use.
Okay, all right, thank you.
Judge, now that I'm seeing this plan, can I speak to it?
You may. Can you speak to it even if I ask Mr. McCatherine to scroll and get me to the last of weeks?
Miss Davis, you don't have a copy of this?
No.
Okay, I'll forward you a copy.
So one of my issues, Judge, well, I have a lot of issues with this, but the one that I specifically wanted to address is this requirement that the unsupervised visits be at the caretaker's home. We're going to then require the caretakers to leave their home for a certain number of hours so that she can do this. I don't think that this plan is appropriate for that reason and others.
Well, I don't mind saying right now that I'm not likely going to wholesale approve this, but by the same today, this schedule proposed. But nor do I want to chill the department and moms and dads doing this. I love this idea, but so I don't know if that makes any sense. Okay. Now, just so I'm sure, JS is just 6 months, correct? Old?
Hold on, I have to count, and I don't count well.
Yes, he's 6 months old and 5 days.
And 5 days, okay.
6 months and 5 days, yes.
Yes, okay, very good. Okay, so again, just the court's just noting and observing that I do like the idea and the effort and the structure of this potentially as a template. Okay, anything else from anyone else?
I do have one additional thing. It's not really related to the visits, but I am asking the court today to sign an order for the redacted records.
No objection.
Okay, so I will sign that order, agreed order, as soon as I see it, and then you all can share that with everyone, Mr. McCatherine, everyone on the case. Just a more not directly related housekeeping. My understanding is that there's been testimony that we have AOPs on both fathers. I know that we have a underlying order with the father of BO, as I believe that the status redirected that child support to the maternal grandparents. So do we have both of these fathers served?
I do not know the answer to that. Let me check with the clerk's office.
Okay, well, I'll certainly be inquiring at the initial perm, which is, well, we know 8 weeks, well, 6 weeks now, I guess, away, March the 21st at 9 a.m. So I'll go ahead and announce our next hearing, which I just did. Our dismissal is October the 9th, 2023. Ms. Oler, remember, every time we're together like this, the law requires me to admonish you that if at the end of this case, you're not willing and able to provide a safe environment for your children, your parental rights may be further restricted or even terminated permanently. I know you understand that. It's increasingly apparent to me that you do not want that to happen. So keep doing what you're doing.
Yes, sir.
So the mother's motion, based on the evidence, the best interest of the children, even the safety specifically of the children, the court's ruling is as follows. As to the child BO, the court orders the mother to have unsupervised visits of the child BO every Saturday and Sunday from at least 8 to 6. Now, this would not preclude the mother continuing to go to her parents' house at 7, so long as they agree. So I'm sure it would be helpful for her to be there to help BO get ready so they can go spend all Saturday together. And I'm gonna have you come back at 6:30 because I want to keep that 8:30 bedtime, okay? And so your mom, you're keenly aware of that. The evidence has shown that you are helping facilitate that bedtime. So that will benefit everyone to keep that bedtime, not the least of whom is the child. So unsupervised every Saturday and Sunday, 8 a.m. to 6:30. Now, as to the child JS, the court continues to take under advisement any unsupervised with him and orders the following. The mother may have unsupervised with JS so long as it's at the placement, but I'm not going to have the placement to leave, but I am going to give them the opportunity if they need to go somewhere, do something, if they want to go somewhere and do something. But you're going to have to stay at their house, in their house with both JS and BO, okay? So you have unsupervised, your attorney can explain it to you, that's unsupervised visitation, but not possession. In terms of going somewhere in the car with JS. Not yet, not yet.
Yes, sir.
If your parents need to go and run an errand, and that may occur for 2 hours a week. Occur at one altogether at one time, and strike that 3 hours, 3 hours. And that may occur at one time or multiple times, several times. Okay. But is so far, do we understand? You may not agree completely, but do you understand so far?
Yes, sir.
Okay. Now back to BO for just a moment. Your supervised with him may occur in whole or in part at your home or your apartment, okay? But the court orders that no one else be present for that visit who are not approved by CPS.
Yes, sir.
So, you know, the president, the governor shows up, the King of England shows up, they can't take part in that visit unless CPS says so. Okay?
Yes.
Right.
So am I able to take BO, like if I wanted to take them somewhere like Chuck E. Cheese, or am I able to do that?
Without.
You may, so long as you're not accompanied by anybody directly.
Just by family.
The requirement, the requirement is for JS only, that unsupervised access would occur at the placement.
Correct.
Correct.
Okay.
So,
For now.
so B is going to be at, there's no restriction as far as where that can take place. Is that correct?
That is correct with the aforementioned restrictions, yes. But again, that's from 8 to 6:30. So pickup would be 8, 6:30 would be drop off. But of course, I'm hoping you're not just dropping off and picking up. I know you're helping, spending every second you can with your children. And I want to encourage you, thank you, and encourage you and commend you on your services. Keep working those, okay? Because there's, I'm guessing, still a whole lot there that you will want to just soak up and learn, and put into practice as soon as
Yes,
possible,
sir.
children. Okay. So we're learning to be protective and to take better care of both the children and their mother. Yes?
Yes, sir.
Okay. All right. Let me look over my notes. You all let me know if there's anything else that you have, any of you has.
I have one additional request, Judge.
Okay. All right. Go ahead.
So we don't know, obviously it's confusing for BO being with his grandparents now and, not really knowing when he can go back to his home. We aren't sure if going back to his home and being there for, that Saturday and Sunday and playing with his toys is going to help him or if it's going to cause more confusion. So I think that Dorothy and my concern is if it causes more confusion, it may not be appropriate for him to go. And that's something that we won't know until they start, which is why we were hoping that Miss Susan Oler, the placement, could kind of be ultimately the decision maker on whether that to continuing going to her home is in his best interest or not.
Well, that's certainly a shared concern that I have. And I would expect, initially at least, there may be some confusion. So I would almost expect that. Might even be concerned if there weren't any. But I would like to also see us try to work through that. Now, if it is such that visits to mother's home, his bed, his toys, are just too detrimental and or confusing to him, then I would like to think that you all could agree that they be changed or that they be stopped. But I also know there's a lot of room for a lot of opinions, and I would probably want, if not need, some sort of expert professional testimony about that. But I really have the expectation that will not be a lingering problem. It'll be a challenge at first, it seems to me. But I think mom and grandma can go a long, long way to kind of mitigating that. But if not, we'll be back here on March 21st. If we absolutely need to come back before then, you all let my coordinator know, and I will get you all in here.
Thank you, Judge.
Your
Okay.
Honor, should I prepare an interim type order
Yes,
in this regard?
please. And I will let everyone else sign it as to form, and then I'll sign it as soon as I see it. Okay. Okay. Mom, keep up the great work.
Yes, sir. Thank you.
And once again, thank goodness for grandmothers and grandfathers. And Ms. Pittman, thank you very much too. Okay, anything else from anyone else?
Your Honor, just briefly before we get off, I see Miss Wright is here. Is Miss Wright, does she represent Mr. Salazar on this case? I have her down.
I represented him at the initial hearing, but he didn't show up and the judge removed me. I always kind of listen to these hearings though, in case I get put back on for some
Exactly.
reason.
So I can scratch her off. I just wanted to make sure.
Well,
Thank you.
don't, maybe just a pencil line,
Pencil?
not a black Sharpie.
So, you know, you never know when somebody's going to appear again or.
Ain't that the truth?
And I want to apologize for my outburst. It wasn't my cat getting the grilled cheese. That was mine. I didn't know anyone was going to call and I thought I was muted already.
Well, believe it or not, Ms. Wright, believe it or not, that's not even the first time that's happened.
Well, I do have spoiled cats, but I don't buy them grilled cheeses.
Well, yeah, no, you probably make them.
Yeah.
Well, you do need to tell me, were you at Sonic or DQ? No, you don't have to tell me.
No, I was here. My secretary were getting food for me, you know, and I'd already ordered it. I didn't know that. No, it's from a nice little place here in Silsbee called Cat's Corner, and that's why you heard the cat.
All right. Oh, well, it's nice to end on a light note, but I still had a hankering for a Route 44 after I heard that. So
yes, those are very good.
all right. Ms. Wright getting ready for Mardi Gras. All right.
Oh yes, yes, and Miss Stanley also.
Oh,
and
always. You know,
and
Ms.
Mr. McCatherine's not going to get to go this year.
Well,
So.
I'm sorry about that. He's probably going to New York or Paris or something.
Probably.
Okay, well, thank you all very much. And Ms. Davis, if I'm behind on some of the orders, I'll get to those in just a minute. Maybe I'm not.
Not for me anyways.
Okay, good. All right. Okay, well, thank you very much. I'll keep an eye out for that order, Mr. McCatherine. Thank you, Ms. Stanley, everybody. You all have a great rest of your week.